want to set the table for you and get you caught up with a short timeline of everything that's happened in this Russia probe and the GOP concerns that dossier was used to get permission to surveil an American citizen. So let's take a step back and get you up to speed on everything that's happened since April of 2016. And that's when the Clinton campaign and the DNC worked with a law firm to hire Fusion GPS to do opposition research on Donald Trump. Then in June of last year, Fusion GPS hires former British spy Christopher Steele to compile the Trump dossier based on info allegedly obtained from Russian operatives. Then in July of 2016, the FBI begins to look into alleged collusion between Trump and Russia. Steele takes a dossier to the FBI and then later shares it with members of the media. Then on October 21st, the FBI and the DOJ use info in the dossier as well as other information to obtain a warrant to surveil Carter Page, an American citizen who was a Trump campaign volunteer. Then on May 17th of 2016, Robert Mueller takes over the Russia probe. On May 17th of 2017, Mueller takes over the Russia probe as special counsel after Jeff Sessions recuses himself from the investigation due to contact he had with the Russian ambassador. So now that you're up to speed, we are happy to welcome in Harvard Law School professor emeritus Alan Dershowitz. He's a Newsmax contributor. He doesn't need to be brought up to speed. He's also the author of Trumped Up. Alan knows this case in and out. Alan, I want to talk specifically about a couple of things. I talked to Tom DeLay. He said under no circumstances should Donald Trump talk to the special counsel's investigators. Our CEO here at Newsmax, Chris Ruddy, says if Trump does talk to them, he should start with written questions. I wanted to ask you, as a defense attorney, what would you advise President Trump to do if Robert Mueller wants to talk to him?
Well, as little as possible, obviously. If he could not have a personal interview, and if he could, as Chris says, just respond to written questions, which his lawyers could vet or even draft for him, that would, of course, be the best possible outcome. I don't think Mueller's going to accept that. The worst possible outcome is if Mueller simply subpoenas him in front of a grand jury. No lawyer, behind closed doors, no time limit, no limit on the types of questions he can be asked. That's the worst possible. And so people are looking for a middle ground. The middle ground might end up being a structured interview with a time limit, with agreed upon subjects in advance, an opportunity to consult with his lawyer after every question, but the fear still exists that he is who he is, and he will not just say, yes, no, I don't remember, which is what all lawyers tell their clients to do in situations like this, but will go on and on and on, and they may find him with an inconsistency. One thing the media is missing: it is not a crime to tell an untruth or even to tell a lie in front of a prosecutor or a grand jury. It's only a crime to do it deliberately, willfully, and when it's material. So if he slips up and makes a statement that turns out to be contradicted by some other statement, that's not perjury. That's not a false statement. That's just something that's human nature. So I don't think the risks to him are as high as some people suggest. Certainly not the risk of perjury. There's always the risk of filling in gaps, that he doesn't know what he doesn't know, and there may be gaps that can be filled in by him in an ongoing investigation if he goes too far afield. But I don't think he's going to have an option, because ultimately the special counsel holds the main card here, and that is the grand jury subpoena.
Well, help me out here, Alan, because Mueller can subpoena Trump, right? But only if Deputy AG Rod Rosenstein signs off on that subpoena, correct?
Well, you know, Rosenstein supervises, but he doesn't micromanage. In general, the grand jury can issue a subpoena. And if the grand jury issues a subpoena, we all know that's a fiction. The grand jury doesn't do anything. The grand jury does what the prosecutor wants him to do. But I think Mueller could get Rosenstein to issue a subpoena. Now, the president has some constitutional grounds on which to object. Of course, he can object on the Fifth Amendment. He's not going to do that. That makes him sound guilty. But he could say, look, I'm not going to answer any questions about my motives behind why I fired Comey. That's a constitutional right I have, and no prosecutor has a right to probe behind what I did and seek out my motives. If you want to ask me that question, we'll take it to the Supreme Court, let them resolve it, and a year from now, we'll be back and we'll be talking again. He could try to do that, but there are going to be questions about Russia, about things that happened during the campaign, that he will not have a constitutional basis other than the Fifth Amendment for not answering, because he doesn't have very many privileges as a candidate or as a transition president-elect.
And so what do you think is the best way to avoid the potential of the subpoena? Do you think that President Trump, if he agrees to, say, submitting answers to written questions, do you think that would be a step that he could take to avoid a subpoena from Mueller?
Well, if I were his lawyer, I would take the initiative. I wouldn't wait. I would file a statement right now, a declaration, in which he states under oath, subject to perjury prosecution, all the potential answers to all the likely questions he's going to get. He can become proactive that way and say, look, I've given you everything you want. If there's anything you want to ask me about, send me a written letter and I'll respond. I don't think he should be waiting for the prosecutor to call the shots. He should try to take control over the litigation through his lawyers. Will it work? I don't know. But he would certainly look better if he took the initiative. He would have then provided lots and lots of information, and the burden shifts to the prosecutor. Say, what haven't you provided me? Ask me more questions. I'm happy to answer them. So that's one tactic he could take. But, you know, he's playing with fire here because Mueller does have the ultimate power to issue a grand jury subpoena subject, as you say, to Rosenstein's approval. Now, you know, Rosenstein has an issue here, too, of recusal, because if I'm Trump, my defense to firing Comey is, wait a minute, I had advice of counsel. The Deputy Attorney General of the United States wrote a memo saying not only I could do it, but I should do it. He's my main witness. Let's call him. He then would have to recuse himself.